Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr law firm. And I'm your host, Alan Kaplinsky, the former practice group leader for 25 years, founder, and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm delighted to be moderating today's program. For those of you who want even more information, either about the subject that we're going to discuss today or anything else in the world of consumer financial, today we're going to be diving into one of the most closely watched developments in consumer finance regulation, namely the CFPB's surprising proposal to overhaul Reg B under the Equal Credit Opportunity Act, which from now on we'll probably just refer to it as ECOA. In the spring 2025 agenda of the CFPB, it hinted very cryptically that it might clarify ECOA compliance obligations. The brief statement set off a wave of speculation. Would the Bureau revisit the so-called effects test or disparate impact liability, especially in light of the Trump administration's executive order? Would it narrow or expand the discouragement provisions in Reg B, which uniquely reach not only applicants, but prospective applicants for loans? And would the Bureau address whether redlining of geographic areas is covered under ECOA? A few weeks later, the CFPB answered all those questions with a sweeping proposed rule. The proposal would eliminate the effects test altogether, significantly revise how discouragement is treated, particularly with respect to prospective applicants, and clarify, some would say completely redefine, the scope of ECOA as it relates to redlining. To help us unpack what the Bureau is proposing and what it means for lenders, regulators, and consumers, I'm joined by three of the country's leading experts on consumer financial services law. First of all, our very special guest, who has been our guest on other podcast shows and webinars that we have done in the past, Brad Blauer. Brad is the principal and founder of Inclusive Partners, LLC. Inclusive Partners' purpose is to help its clients better understand and navigate the regulatory, compliance, and legal landscape of providing sustainable financial access to underserved communities. Brad's a nationally recognized fair lending and civil rights expert with decades of experience at the intersection of consumer protection, data analytics, and financial services policy. He's held senior fair lending and compliance roles in both government and industry, including serving at one time as Vice President, Director of Fair Lending for the National Community Reinvestment Coalition. Brad is widely regarded for his deep understanding of ECOA, Reg B, and the practical implications of emerging fair lending standards. Well, Brad, a very warm welcome back to our show.
Thank you, Alan. Really appreciate it. Enjoyed our conversation last time.
Yep. Let me now introduce my colleagues at Ballard Spahr who are going to join Brad in the discussion that we're going to have. First, Rich Andreano. He's one of the country's leading attorneys in consumer financial services regulation, with extensive experience advising lenders, mortgage companies, and financial institutions on fair lending risk and compliance. As the practice group leader of Ballard Spahr's mortgage banking group, Rich has spent decades counseling institutions on ECOA, Reg B, HMDA, and supervisory and enforcement trends involving discrimination and disparate impact issues. He is a frequent speaker and a trusted authority on the CFPB's fair lending agenda. Rich, a warm welcome to you as well.
Thank you very much, Alan. Glad to be here.
And last but certainly not least is John Culhane. John is no stranger to any of our listeners on our podcast shows and webinars. John is a seasoned consumer finance lawyer with a long record of advising banks, fintechs, and specialty finance companies on fair lending, credit access, and discrimination-related compliance matters. He is a senior founding member of Ballard Spahr's Consumer Financial Services Group. His work focuses heavily on ECOA, Reg B, and the fair lending and UDAP issues that arise across the credit life cycle. He's known for translating complex regulatory developments into practical guidance for industry stakeholders. Now, let me say that very recently, on November 13th and 20th, we released a two-part webinar series featuring Brad, Rich, and John, entitled Fair Lending Developments Under Trump 2.0. However, at the time that we recorded and later released this two-part podcast series, the CFPB had not yet proposed these extensive amendments to Regulation B. Thus, the need for, in effect, starting over, because now we know. Back then, we were speculating what the CFPB might be doing. We didn't know precisely what they would be doing. So anyway, I want to thank all of our presenters again, and let's get started. So, Brad, I've got the first question for you, and that is, in June 2015, and actually more than a decade ago, the Supreme Court, in the case called Texas Department of Housing and Community Affairs versus Inclusive Communities Project, held in a 5-4 vote that disparate impact claims may be brought under the Fair Housing Act. Has the Supreme Court ever addressed whether disparate impact claims may be brought under ECOA? And I guess, Brad, because we shouldn't assume that everybody's got the same level of knowledge as the three of you, maybe you could very briefly just define what a disparate impact claim is before answering my question.
Sure. Basically, disparate impact is that you can discriminate without intent. That if you have a facially neutral policy or practice that has an adverse effect on people in protected classes, as defined by COA, that is discrimination. So you could have an AI model. You could have a policy of, one of the famous cases was a policy of when someone died on a credit card account and their spouse was on a supplemental member of that account. That Amex, there's a well-known case, Miller v. Amex, that said, if you cancel all the accounts, a lot of women are going to be adversely impacted by this policy at American Express. They'll have the adverse impact of cutting off women from credit. So even though the policy was neutral, it was just, we're going to cancel an account when the main holder of the account dies, it had an adverse impact. So that's disparate impact. And to answer your question, the Supreme Court has not addressed whether disparate impact a claim can be brought under ECOA. It has, as you mentioned, in inclusive communities under the Fair Housing Act. And certainly a lot of circuit courts and district courts have also held that you can bring a disparate impact claim under ECOA, but not the Supreme Court. Has not touched the issue yet.
Okay. So Section 804A of the Fair Housing Act provides that it shall be unlawful, and I'm quoting now from the statute, to refuse to sell or rent after the making of a bona fide offer, or to refuse to negotiate for the sale or rental of, or otherwise make unavailable or deny a dwelling to any person because of race, color, religion, sex, familial status, or national origin. Justice Kennedy, writing for the majority in the Inclusive Communities case, focused on the language otherwise make unavailable, that language that I quoted. And he found that the language, and I'm quoting again from his opinion, refers to the consequences of an action rather than the actor's intent, unquote, and thus supports a disparate impact claim under the Fair Housing Act. So my question for you, John, is does ECOA have that similar language, otherwise make unavailable language?
No, Alan, it does not. The ECOA prohibits discrimination on the basis of certain protected characteristics against an applicant because of certain protected characteristics. It doesn't have or otherwise make unavailable. It likewise doesn't have language like in the Age Discrimination and Employment Act, otherwise adversely affect. It doesn't have that kind of language. It simply prohibits discrimination on a prohibited basis.
Okay. So I quoted from Section 804A. I'm now going to quote from Section 805A of the Fair Housing Act. It provides that it shall be unlawful for any person or other entity whose business includes engaging in real estate related transactions to discriminate against any person in making available such a transaction or in the terms or conditions of such a transaction because of race, color, religion, sex, handicap, familial status, or national origin. So, unlike Section 804A, Section 805A uses the phrase, quote, in making available, unquote, and not the, quote, otherwise make unavailable, unquote, language that Justice Kennedy found to be important to the determination that the Fair Housing Act supports claims of disparate impact liability. Yet he still found that disparate impact claims may be brought under Section 805A of the Fair Housing Act. So my question to you, John, again, does ECOA have that language similar to what I quoted in 805A?
It does not have the in making available language either, although I think it's noteworthy that the CFPB, in looking at the inclusive communities opinion, found that discussion of Section 805 to be a bit hard to follow and basically said that they couldn't really tell what lessons they were supposed to learn from that discussion, but they could tell that those words weren't in the statute. All of that the ECOA says is that it's unlawful to discriminate with respect to any aspect of a credit transaction on the basis of or because of. It doesn't have the making available or otherwise making available language.
Right. So, Rich, let me go back to you now. Does ECOA have any other language that's typically found to support a disparate impact theory of liability?
Not in my view. And what I'll do is actually quote from the main prohibition under the statute, because the Bureau spends a lot of time in the preamble to the rule focusing on that. So I think it's important to review. And it has the language that John has referred to. And it's fairly short, and there are three separate prohibitions. And it's unlawful for a creditor to discriminate against an applicant with respect to any aspect of a credit transaction. One, on the basis of race, color, religion, national origin, sex, or marital status or age. 2, because all or part of the applicant's income derives from a public assistance program. Or 3, because the applicant has in good faith exercised any right under the Consumer Credit Protection Act, and ECOA was part of the Consumer Credit Protection Act that also contained TILA and some very other important consumer financial protection statutes. So I read on the basis of and because to be intentional discrimination and not disparate impact. And in fact, in the inclusive communities case, in the dissenting opinion, it focused on not on the otherwise make unavailable or making unavailable language later on that used the term because and said because is intentional.
Okay. So, Brad, why then did the FRB conclude, as set forth in the current version of Regulation B, that the disparate impact theory should apply?
Yeah, well, here is the classic situation of the legislative branch not quite getting it right, but in the legislative history of ECOA, which the Bureau has acknowledged both in the old version of the current version of Reg B and in the proposed changes to Reg B, there was very clear legislative history that no credit application should be denied on the basis of characteristics that have nothing to do with creditworthiness, and that there's no requirement to show that there's a specific intent to discriminate. So looking at that legislative history, looking at the statute and finding, as in many statutes, agencies have to issue implementing regs and rules. And I think the FRB at the time made a good faith judgment that for this law to be effective, you would have to include disparate impact. And that was certainly what Congress intended as part of its deliberations on enacting the law.
Okay, so there are statements in the legislative history of ECOA that indicate that disparate impact claims are cognizable under ECOA. How does the CFPB respond to those statements in the proposed reg or in the supplementary information?
They basically acknowledge them, but then say, really, it's, you really have to look only to the statute. And that's what the Supreme Court did in inclusive communities when it was looking at the Fair Housing Act, and then Smith v. City of Jackson and reviewing another anti-discrimination law. And so it's really textualism over looking at the complete package of the legislation is the current CFPB's approach to this. And so although they acknowledge the legislative history, they then move on to say we're going to disregard it and look only to the language of the statute.
And how does the CFPB, John, now propose to address disparate impact?
Well, having said that they can't find the authority for it in the statutory language, and not finding the legislative history in the Senate and House committee reports going back to the 70s at all persuasive, basically the CFPB is now proposing to delete all language in either the regulation or the commentary that refers to disparate impact or the effects test, basically negating regulatory text that had been first in a footnote and then moved into the regulation itself, and then deleting similar language from the commentary and adding an affirmative statement that, in fact, there is no prohibition on practices that are facially neutral as to prohibited bases, except to the extent that those facially neutral criteria might serve as proxies for protected characteristics. And that's where they stop. They do not elaborate on what they mean.
People were thinking of commenting whether the CFPB should consider other alternatives. And in this case, it would be an alternative other than just wiping out disparate impact theory and the effects test altogether.
And this was interesting because when I started reading it, I realized they weren't proposing an alternative to removing the language. They were proposing a different theory to get to the same result, which is I found interesting that they did that. What they raised, and some courts have raised this with regard to the disparate impact theory about needing to be careful about how it's applied, is unequal results, unequal being unequal based on prohibited basis, one or more, might cause creditors to actually consider prohibited bases to get more balanced results. So it could actually force the consideration of prohibited bases in a way that would violate the Equal Protection Clause under the Constitution. And they said that's a concern they have. And so what they were thinking of is maybe the theory is because not just look is not just looking at the statutory language, but because of this theory, maybe we should also remove that. They then note that no court has ruled on that theory specifically. They then also point to the Loper-Bright case, and that was the important decision last year where the Supreme Court overruled the longstanding Chevron doctrine, where courts in various situations would defer to an agency's consideration of an issue, even if the court thought it had a better idea. And the Supreme Court finally wiped that out. And it notes, the Bureau, that the Supreme Court said that courts are the ultimate arbiters of statutory meaning. And that's odd, I think, because while it acknowledges that now the Supreme Court has said courts are the ultimate arbiters of statutory meaning, the Bureau plans to, under its interpretation, remove the effects test language from Reg B. I would suspect some people opposing that might point out that language from the preamble, that this should be done by courts and not the Bureau. So we'll have to see what happens there. But it's odd. They asked for comment on an alternate theory, not on an alternate result.
Yeah, on Loper Bright, did they say anything about the fact that at least, well, I believe this is true, maybe I'm wrong chronologically, at the time that Reg B was promulgated, the current version of Reg B, was there such a thing as the Chevron deference doctrine? Or was that something that happened later?
Boy, they were close in time, I think, because it was 74 that we got the Consumer Credit Protection Act. Wasn't Chevron also right around that time, I think?
Yeah, I don't know if it was the same year, but I think within a year or two. So, and then, I guess we can't directly answer that question now. But what I was getting at is if Chevron had not yet come down from the Supreme Court, there was a different doctrine that applied then. It was not Chevron deference. There was no requirement that a court follow a regulation where the statute's ambiguous and the regulation is a reasonable interpretation. But clearly, what the CFPB is doing now is clearly subject to Loper Bright. I mean, there's any doubt about that. So I don't know if that ultimately what makes a difference or not.
Well, and ultimately, I would just add, Alan, that it's a bit ironic that groups that really wanted to be restrictive of government were pushing the Loper Bright challenge, right? And some of these same groups have been itching to challenge a disparate impact under ECOA and get it to the
rulings where they would defer in an area of agency expertise if the agency was persuasive in what they did, but it wasn't the more absolute deferral that was in the Chevron doctrine.
Got it. Okay, let's turn to the second area that the CFPB dealt with in the proposed amendments to Reg B, and that is the discouragement provisions. The regulation currently provides, and I'm quoting again, a creditor shall not make any oral or written statement in advertising or otherwise to applicants or prospective applicants that would discourage on a prohibited basis a reasonable person from making or pursuing an application. So, Brad, who's an applicant and who's a prospective applicant for purposes of this prohibition?
Yeah, an applicant would be somebody who has started the application process for a credit product. And a prospective applicant would be anybody in the community who was considering applying for a loan. And this is important as we discuss the new proposed regulation on discouragement as it relates to discouragement, because the CFPB has a very specific definition of who they consider to be prospective applicants. that's a little different.
Right. So, Rich, I'm going to ask you this question. In addressing the discouragement provisions in the preamble to the proposal, the CFPB explained, and again, I'm quoting from them, it's concerned that the overbroad coverage of the regulation and its potential interpretations may constrain free speech and commercial activities in ways that are unwarranted. What do you think prompted that concern?
I think a lot of this, because a lot of the language that's in the preamble is very consistent with language that the current CFPB leadership has used when referring to the Townstone financial case. Now, this was actually a case brought during the first Trump administration, which some people forget. They think it was brought later, but no, it was brought in the first Trump administration. And it was a redlining case brought under Equal Credit Opportunity Act. What was unique about the case, different from other redlining cases, is the heads of the company, they had a radio show and also podcasts, and they made statements during those referring to certain areas in Chicago that the Bureau viewed would discourage prospective applicants from applying on a prohibited basis, specifically black applicants or areas, because were viewed as disparaging remarks regarding some of these areas. That ultimately resulted in the case in a stipulated final judgment and order in November of last year. And then, believe it or not, in March of this year, the current CFPB leadership moved to have that consent order vacated because of what they believed was an improper prosecution of Townstone. The judge denied that in June of 2024. But what the current leadership said at the time is they thought the Bureau, under prior leadership, unfairly targeted Townstone for making what current leadership believed was constitutionally protected free speech. So if you then go to the preamble, there are some pretty direct statements in this area, and I'll quote from them where they say, in the year since the Federal Reserve Board first adopted the discouragement provision, it has been interpreted to prohibit conduct that is not necessary or proper to prohibit or prevent, and there was a typographical error there, so I changed a word there to or, prevent the circumvention or evasion of ECOA's purposes. And they're concerned that this in turn has unnecessarily had a chilling effect on creditors' business practices as an exercise of their rights to speak about matters of public interest. And then, to me, the key phrase, they go on and say that they're concerned that the overbroad coverage of the regulation and its potential interpretations may constrain free speech and commercial activity in ways that are unwarranted. And these are consistent with statements they made regarding the Townstone case. So I think while they don't expressly tie this proposal to the Townstone case, I think it was a great motivating factor in why we have this proposal.
Which again is ironic because,
John, we've been talking about, what's in the current version of Reg B regarding discouragement. Why don't you tell everyone what the CFPB is proposing to do with the current language?
Well, they're basically proposing to flip the test. And while the current language focuses on the understanding of the applicant, a reasonable person who is an applicant, the new test, or the test that's proposed, focuses on the understanding of the creditor. So we're now looking at whether a creditor, or we would be looking if this were adopted, whether a creditor knows or should know that its actions or statements would cause a reasonable person to believe that the creditor would deny or would grant on less favorable terms a credit application. So we've added, while the reasonable applicant is still there, the main focus now is going to be on what the creditor knew or should have known about the statements or words that act as being discouraging.
So the Regulation B commentary contains a bunch of examples of statements that would constitute prohibited discouragement under existing law. How does the CFPB propose to modify the examples?
They're getting rid of the general statement that the use of words, symbols, models, or other forms of communication that express, imply, or suggest a discriminatory preference or policy constitutes discouragement. And instead, they're adding a example of prohibited discouragement, a general example, and then some specific examples. The general example being statements addressed to the general public that express a discriminatory preference or policy of exclusion based on one or more of the prohibited bases characteristics. And then they've added a bunch of examples of statements that are not prohibited discouragement, which, as Rich was saying, in some respects are evocative of the Townstone situation. But there are statements directed at one group of consumers, encouraging that group of consumers to apply for credit. That's not prohibited discouragement. So you don't get the flip side that by encouraging part of the population, you're deemed to be discouraging other parts of the population. Statements in support of local law enforcement are not discouragement. Statements recommending that before buying a home in a particular neighborhood, you look at the aspects of that neighborhood, including schools, proximity to stores, crime statistics. Again, that's somewhat evocative of statements that were made on the Townstone radio show. And then statements encouraging consumers to seek out resources to develop their financial literacy are viewed as not being discouraging at this point. So they're not interpreted as a warning to come back once you're financially literate. They're viewed as just a sort of a general exhortation to the public that financial literacy is a good thing.
John, did the CFPB in the proposal provide examples of what would constitute prohibited discouragement?
Well, the one I can remember, I can step in. I mean, there was the only thing that they provide. I mean, it was the only positive thing about the discouragement new rule is they kept in discouragement. Okay, that's good, and so prospective applicants are covered. But they did provide the example. You can't put a sign in the window that says only people who are under 65 can apply for a loan because that would be age discrimination. That's the only example that they gave.
Right, right. A very, very direct example.
Yeah, sure. So, Brad, the commentary currently includes an example of activity that would not constitute prohibited discouragement. Specifically, it provides that a creditor may affirmatively solicit or encourage members of traditionally disadvantaged groups to apply for credit, especially groups that might not normally seek credit from that creditor. Does the CFPB plan to make any changes to that comment or to add any further examples?
I'm not aware of currently, but in the commentary on this rule that's being proposed, the changes to Reg B, I mean, they do say that things that are usually the signs of redlining, like where you put your branches of your bank, where you advertise, and where your loan officers direct their attention, are not considered discouragement if you apply. If you for example, let's say you put all your branches in just white communities, you have your loan officers concentrate their calls in white communities, and you only advertise in white communities under the way that this rule is, the changes to Reg B are written, that would not be considered discouragement to blacks and Hispanics and other communities. And the normal interpretation of discrimination and discouragement is it's the other side of the side of the sword. You know, if you're not getting the encouragement and the carrots to apply, that's discouragement. And this rule flies in the face of that.
I just wanted to add, maybe Brad, you can react to this. I mean, they don't specifically talk about closing branches here, which sort of leaves open the possibility that while the affirmative placement of branches may not be discouragement,
A critique by advocacy groups when certainly, like for instance, when there are bank mergers and a bank will close the branches in some of the minority neighborhoods and not the ones in the white neighborhoods, that's considered discrimination by most advocates. So we'll see how that's enforced.
Yeah. While the CFPB's proposals would clarify and limit what constitutes discouragement, it generally retained the references to prospective applicants. Rich, did that surprise you?
Somewhat, yes, because particularly based on the reaction to the Townstone case and thinking it never should have been brought. One thing I thought they might do is the way to stop the CFPB from going down that path again would be to remove the prospective applicant references from the reg, because the COA itself focuses on applicants, but the reg also makes clear that the prohibitions apply to prospective applicants. They decided in the end to take, that might have been, perhaps they thought, a bridge too far, and they decided to take a milder approach, which was to raise the bar on what constitutes prohibited discouragement, perhaps figuring that that might be more legally defensible than completely removed.
John, did the CFPB propose to delete any references to prospective applicants?
Well, oddly enough, they did propose to delete one of the references to prospective applicants, which makes it a bit hard to follow their analysis here. There's a provision in the statute and a comparable provision in the regulation that protects self-tests, so that if a institution does its own testing to see whether there might be any practices that would be or that could be considered discriminatory, it has a self-testing privilege. And there's an affirmative statement currently in the regulation that that privilege can be invoked against claims or attempts to seek a self-testing report by the government or by applicants or prospective applicants. Prospective applicants, I think, is in parentheses. Oddly, they're deleting prospective applicants here on the grounds that that language doesn't appear in the statute anywhere. That's certainly true, but it not only does it not appear anywhere in the self-testing provision in Section 704A of the ECOA, it doesn't appear anywhere else either. So it's kind of an odd result that they would take it out there. And it leaves kind of a weird result, because it looks like prospective applicants now might be able to seek a self-testing report, and the self-testing report wouldn't be protected by the privilege. So it's more than a little confusing as to what they've intended to do here.
Right. So let's turn now to
That appears to be because of the way the special purpose credit program provision exists in the ECOA. It lays out those three categories and says nothing about rulemaking with respect to programs expressly authorized by law, which are government programs. Nothing about credit assistance programs offered by nonprofit organizations. But with special purpose credit programs offered by a profit-making organization, there's an express grant of rulemaking authority. Those programs are permissible to the extent that they meet standards prescribed in regulation by the Bureau. So that appears to be the specific grant of rulemaking authority here appears to be the basis for the distinction.
Brad. I want to turn to you now. An important element of a special purpose credit program is that it allows the use of one or more prohibited bases to determine the eligibility for the program. Does the CFPB propose to change that? And if so, how?
Under the current version of Reg B, you can do a special purpose credit program that's either people-based, it's based upon the demographics of the people who qualify for the program. So under the current reg, if you devised a program that was, you saw that you weren't lending to as many African Americans and Hispanics, you could devise a program that was targeted to those communities. Or you could do it by geography. Under the proposed change to the reg, you could not use, it has two categories. It has characteristics you cannot use anymore under the new rule, and that's race, color, national origin, or sex. And the commentary in the rule makes the extraordinary statement that says, hey, things have changed a lot since 1974, and we're not aware of any discrimination going on in the credit markets based upon race, color, national origin, or sex anymore. And we invite people to provide us evidence that that's still going on because we don't think it is. Pretty extraordinary statement. But it says, but we will, in a restricted way, allow you to still use religion, marital status, age, or income. But only if you show that people are actually being completely excluded from your lending program. That they actually have to actually not be able to get a loan with your program. Whereas under the existing version of the rule, you can show, look, through statistics and our lending rates in different communities, we're showing that probably people in certain protected classes aren't able on an equal footing to be equally served by our institution. So we're going to do the special purpose credit program. You can't do that anymore as a for-profit. You have to show that people are actually being excluded. It's going to be a very high bar to meet for any financial institution.
To use religion, marital status, age, and or the receipt of public assistance income as a factor to determine eligibility for a program, a creditor would need to make an assessment as to each individual applicant that they would not qualify for credit without the program. How does that proposal differ from the current provisions in Reg B? Let me ask you, Rich.
The current provision has a less stringent standard, and what it requires is that the for-profit entity's program must be established and administered to extend credit to a class of persons who, under the organization's customary standards of creditworthiness as granted, probably would not receive such credit or would receive it on less favorable terms than ordinarily available to other applicants. So several important differences. One, the proposal requires, the way I read it, a determination as to each specific applicant, not a determination as to a group of persons where that's very different. So I think that's more liberal than what's being proposed. Second, the decision doesn't have to be definitive. It's probably would not get credit, not definitively would not get credit. Third, it allows, you could actually determine, no, this applicant or group of persons would get credit, but they'd get it on less favorable terms. The proposal is always, it's all or nothing. You wouldn't get credit. It's not, it would be on less favorable terms. So I think the existing standard is much easier to satisfy than the proposed standard offered by the Bureau. And, so I think that's going to be a big factor, even as to these limited qualities. It would limit the ability to offer programs to this group.
So Rich, my understanding, tell me if you disagree, and John too, under this new rule, a version of the reg rather, you couldn't bring a claim for otherwise receiving less advantageous terms. You could only bring a claim if you were denied credit, if you thought you were being denied credit.
That's why I read they're limiting it to being denied credit, not getting it on less advantageous terms.
Yeah. So, John, if these proposals are adopted, that would force many for-profit entities to modify their special purpose credit programs to remove race, color, national origin, or sex, or any combination thereof, of the applicant as a common characteristic or factor in determining eligibility for the program. If the entities decide to switch to other factors that are not these prohibited bases, will they be protected from liability?
Well, not necessarily, because of the comment I made earlier about proxies. There's still the notion of certain attributes being proxies for these particular characteristics, and so that remains, and we not only have to be sure that you weren't using any of the direct prohibited bases here, but real prohibited bases here. You'd also have to be careful about not using proxies. Otherwise, you're left in the same situation.
So, Brad, what is a proxy for a prohibited basis? That's an important issue. And does the current Reg B
a white person? And there have been cases where mortgage lenders were not making loans on row houses, and successful litigation challenged those underwriting restrictions, saying, that's a proxy for race. If you say we won't accept as collateral a row house, but for instance, we'll accept a townhouse in the suburbs of the city, which is predominantly white. So those are some examples of proxy considerations, but there's no guidance in the rule.
Do any of you have any thought on what the CFPB might have been thinking here? Because it seems to me, that while with one hand, they have gotten rid of disparate impact and the effects test, on the other hand, through this so-called proxy test, sounds to me like they're similar things. Maybe they're not identical, but I'm having difficulty making a distinction. Any of you have any thought on what you think the CFPB was thinking?
They seem to, I guess, perhaps support their proposal to eliminate disparate impact by indicating that under the disparate treatment theory, use of proxies would still be prohibited. I think they're trying to say, no, there's still a way for people to get to the same result. I don't think they're exactly the same. And with this administration, though, they might use proxies more as thinking that, you're discriminating against white non-Hispanic individuals through the use of proxies that provide favorable programs, perhaps in lower income areas. That's the concern I have, is how this government might use proxy theory under disparate treatment.
And so there's maybe some kind of crossover between this and Trump's executive order dealing with fair access.
Yeah, I think a lot of this, the policies of the administration announcing executive orders, I think, are very much behind what's going on here.
Right. So to wind up our discussion on special purpose credit programs, I want to ask Rich the following. The program proposals are limited to programs offered by for-profit entities and not programs offered by government entities or nonprofits. Do government entities or nonprofits have anything to be concerned about with this proposal?
I unfortunately, I think so. One thing we were surmising when the Bureau indicated it was going to consider rulemaking under ECOA, particularly we thought, given the Trump administration's focus on what used to be reverse discrimination, or discrimination against white non-Hispanics or males, non-seniors, the thought was that there's just discrimination in their view. There's no reverse discrimination and discrimination. Would they, and they were doing that on equal protection grounds, would they raise the issue of whether the special purpose credit program provisions of ECOA present constitutional issues under the Equal Protection Clause? And they went there in the preamble. Now, they did it in the context of for-profit special purpose credit programs, but I think the theory would apply to government and nonprofit as well. And the first case they cite in raising this issue, because they say recent Supreme Court precedent has us concerned here, they cite the Students for Fair Admissions versus Harvard case, which is the case a couple of years ago where the Supreme Court knocked out the express use of race in college admission determinations. So I think that's a concern, and we'll get to in a little bit at what may be an ulterior motive of the Bureau here in making this proposal. But I think government and nonprofit programs need to be vigilant on this proposal, because it's the clear shot across the bow.
So a question for you, John. For such a significant proposal, and I think people on whatever side of the issue you're on, you would agree this is significant. The CFPB provided a very short comment period. The rule was published in the Federal Register on November 13th, and comments are due by December 15th. So it's a comment period of only 30 days. Do you think this signals, John, that they may attempt to adopt a final rule before they run out of funds to operate? And let me just remind our audience that several weeks ago, maybe it's even a few months ago, Acting Director Vogt came out and said they're going to be running out of funds within 2 to 3 months. And people thought that meant by the end of this year, or maybe it would leak a little bit into January. But they were clearly running out of funds. And I think most people who followed the CFPB and got into the numbers and figured out what their expenses have been. They still have a lot of employees on their payroll because there is an injunction right now precluding them from terminating any of these employees. Agreed that that Vogt was probably stating it correctly. And then to make matters even more difficult, the next thing that happened was a notice issued by the CFPB to the Federal District Court in the District of Columbia before Judge Amy Berman Jackson, the judge that had issued the injunction initially precluding the reductions in force and other actions that the CFPB was about to take. A notice was sent to the judge saying, I'm attaching an opinion from the Department of Justice Office of Legal Counsel, and here is a detailed opinion basically saying, even if I wanted to get more funds in order to do the statutorily required things, I just want you to know, Judge Jackson, that my hands are tied. The Office of Legal Counsel said it would be unlawful funding under the language in the Dodd-Frank Act that says CFPB can only request and can only receive funding from the Federal Reserve Board out of combined earnings of the Federal Reserve System. That's an issue that there's a lot of disagreement about what the word earnings means. Does it mean revenues? Does it really mean profits, meaning revenues minus expenses? We don't have a definitive answer to that. So one wonders, with all that going on, what are they going to do? How are they going to have time to read? They're going to get a lot of comment letters, I'm sure, from people on both sides of the aisle here. Ordinarily it takes several months to go through all these comment letters. Do you think they're just going to try to issue a final reg before the end of the year and say they looked at all the comments? And I mean, how's this ever going to get done?
That's a good question, Alan. Certainly the suggestion here is that they want to wrap this up before they shut down the Bureau. I guess you can conclude from the short time frame, I guess that's the reason they have said they only need 30 days. Well, both of those are reasons why they only need 30 days. But it's hard for me to believe that, given the comments that this proposal is likely to spawn, that they can do a real meaningful analysis of the arguments that are presented in the comments. And I don't mean the rubber stamp comments of people that are identical except for changing names, but the comments from consumer groups and financial institutions and proponents of special purpose credit programs, how they can possibly do a thorough analysis of those comments in a 30-day period that includes 2 holidays.
Yeah, and I should say, I represent some groups that have already asked for an extension of time of the Bureau of the 30 days, so that there's ample time to provide comments. Even some of the issues we've raised in today's podcast are unclear. There needs to be a period for this, and so it's talk about rigging the game. I mean, it's essentially an attempt to say, well, our hands are tied, money's about to run out, we're going to make the rule final. And I think that's the intent here. It's just to cram through.
Did they actually deny your request for extension, Brad?
It's pending. It's pending. Many groups have asked for an extension of time.
Oh, many. Okay. Yeah, a very quick adoption of a final rule, John, do you think raise issues under the Administrative Procedures Act? In other
Yeah,
words,
I do.
yeah,
I think there would be definitely be issues under the Administrative Procedures Act, and I think it would be an uphill battle to say that there was meaningful consideration of the comments that were received. Again, it's not just the 30 days; it's the two holiday periods in embedded in that 30-day period. They're staffing as well, and they're staffing as well.
yeah. I mean, we really, I don't know if we know who's really working on this regulation. There are any legacy staff members working on it? Or, in other words, are they people who are expert in Reg B and ECOA? Or are they people who have been sort of deputized or sent to the CFPB from OMB or another agency to fill in for the people that have all the experience and expertise?
It's a little unclear, but certainly the people who had expertise were forced out of the agency, either constructively or directly by being riffed. And so the people that I know who would have normally been working on these rules and are seasoned and have been at the Bureau for a while and understand issues are gone.
So I take it, while there's nothing specifically in the APA that says an agency must, in its issuing any final rule, must deal with any substantive comment or critique of the proposal that doesn't get put into the final rule, that's all laid out. The criticism is put into the supplementary information. There's nothing that specific, but if things are really jammed through, pretty easy to conclude that.
There's nothing in the APA that requires a response to each comment that comes in on a regulatory proposal, but there is a directive to consider. I mean, that's the whole purpose of a comment period. A notice and comment period is to think carefully about what the final rule will be.
Right. And of course, I'm sure there are other issues that are going to get raised other than the timing issue, that the changes that they're making are, what's the language of the APA? The arbitrary and capricious, I think. And there'll be Loper Bright issues as well. They also indicated, Brad, that any final rule would be effective 90 days after publication in the Federal Register. Why 90 days? Do you think the final rule adopting the amendments are going to face legal challenges before the rule becomes effective?
Absolutely. I mean, I already know groups are gearing up on the advocacy side to file such lawsuits. And you saw this when HUD, under the first Trump administration, changed the disparate impact rule. It was immediately challenged. There was an immediate injunction in court staying the implementation of the new rule, and it never went into effect and was later rescinded by the Biden administration. So you're going to see court cases from various groups within the 90 days, and it will be challenged. And I think you will have lower courts to join it, particularly as to disparate impact and discouragement, because there's ample case law from the last 50 years interpreting to find that disparate impact does apply under ECOA and that discouragement should be broadly read.
And of course, within that 90 days, my guess is that the CFPB is pretty much shut down. They've already, I think, gotten rid of all of their attorneys who we would consider litigators. And they've said that the Department of Justice from now on will represent the CFPB. So I guess they'll be able to litigate this issue. It'll be done by people at the Department of Justice who probably know practically nothing about ECOA and Reg B. Maybe I'm being unfair, but I don't think people ordinarily take jobs at the Department of Justice because of their expertise in consumer finance and specifically Reg B and ECOA.
Those attorneys would be at the Bureau or at the Federal Trade Commission. But no, I mean, this administration certainly has no qualms about putting people who have no experience in certain areas into that role at the Justice Department. I
Yeah,
won't name specific instances, but we had a very recent instance of that on the criminal side, right?
yeah, right. I know. I think everybody knows what you're referring to, Brad. So, Rich, final question. Do you think that an ulterior motive of the CFPB and the Trump administration with respect to the proposal is to trigger lawsuits that get these issues before the courts and ultimately before the Supreme Court?
I think that's their ultimate goal here, given the composition of the Supreme Court with the six conservative justices and how they've ruled in other cases. It's a mortal lock that there'll be lawsuits. I think Brad's right. The lower courts will rule against the Bureau, but the whole goal, I think, of the Trump administration is finally get before them, particularly the issue: can you bring disparate impact claims under the Equal Credit Opportunity Act? And remember, under inclusive communities, the court looked a lot, even though the court looked a lot different, that was still a 5-4 decision. So it was the narrowest majority. I think everyone would guess on this issue would probably be a 6-3 decision. No, you can't bring disparate impact claims under ECOA. And then obviously that's not the end of the road. Congress could always amend the statute in that case. So that issue would remain open. The discouragement, yeah, they may get to the issue of does ECOA apply to prospective applicants. That could be an issue they're trying to get before the Supreme Court, and I think the court would rule no, it only applies to applicants. Again, if they did, Congress could amend the statute and define that and make it clear. The big one is special purpose credit programs. If they rule that those provisions are unconstitutional, then there's nothing Congress can do about it at that point. It would be a done deal. You'd have to amend the Constitution, and that's never gonna happen. So I think that's their goal, to get these issues up before the Supreme Court, and that may be a reason why they're moving so quickly, because they don't, fine, challenge the rule. We'll just keep bringing it up, and now that the federal government's funded, at least for now, the DOJ does have funds to defend the lawsuit.
Yeah. Although it's conceivable, I think, while I agree with you on substantively where the Supreme Court would probably come out on these issues, this thing they may not like. Even the conservative justices may think that there are some APA problems here. If this thing is really jammed through the way we think it might be before they run out of money. And let me just add one final thing, because I just blogged about this in our Consumer Finance Monitor blog. And that is that Bill Nelson from Bank Policy Institute recently posted on a LinkedIn page that he thinks that the Federal Reserve System is turning a profit, that by the end of this quarter, they will technically have a profit. And at the low point, that is where every month the amount of losses that they were incurring kept increasing. It's now coming in the other direction, and they may very well have profits. There's an argument we don't have time to get into that that's still, while they may be turning a profit, they have to, before they turn over money to the CFPB, they've got to get rid of the deferred asset on the balance sheet of the Federal Reserve banks. That deferred asset, meaning that they've got the right for the Federal Reserve banks to retain any profits that they have until that asset is eliminated, or put differently, before they have to send money over to the Treasury. Because the general rule is that the profits of the Federal Reserve banks get paid to the Treasury. But anyway, we're getting too much into the weeds, and I have a feeling we're probably going to want to revisit this issue in a few months after we see what actually happens. Does the final reg get issued? What does it look like? What kind of litigation is pending, et cetera? I'll give each of you the right to have the final say. Let's go in the order: Rich, John, and then our special guest, Brad Blower. Any final thoughts or comments?
Yeah, the proposal pretty much is consistent with a lot of what you've seen in the executive orders and other actions by the Trump administration to really dismantle a lot of fair lending law. And the difference here is this is going to end up in the courts, and there's some court precedent that's contrary to what they're doing. So it'll be interesting to see how this progresses.
Okay. Thank you, Rich. John, anything to add?
I just agree. It's going to be interesting to see how it progresses, and the length of the preamble of a final rule, I think, is probably going to be very telling as to exactly how much consideration has been given to the comments that have been submitted. We've become accustomed to seeing these multiple 100-page preambles come out of the CFPB. I don't think that's going to be the case here.
This might be just one or two sentences. We have carefully read and reviewed and studied and analyzed every comment that came in, and we find none of the comments are worthy of changing anything. Okay.
Well, that's probably the first draft, Alan, but I think there'll be a little more than that, but I doubt there'll be a exhaustive.
Right. So, Brad, as our special guest, you get the final say.
Yeah, I would urge people to get in comments. We need a record that shows that a lot of comments were submitted, not just on the issues we've discussed, but others as well, other flaws in the process, and that it's kind of a tragedy that you had a disparate impact and discouragement system that was in place. Businesses understood it, consumers understood it. There were 50 years of jurisprudence that accepted it, and now there's a lot of confusion, and so that's problematic for both consumers and for financial institutions.
Yep. Well, I want to thank you, Brad, and of course, I want to thank my colleagues, Rich and John, for taking the time today to really take a pretty deep dive into the CFPB proposed amendments to Regulation B under ECOA. And to make sure that any of our listeners don't miss our future episodes, you can subscribe to our podcast show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or whatever platform you use. And don't forget to check out our blog, Consumer Finance Monitor, same name as the podcast show, for daily insights on the financial services industry. And if you have any questions or suggestions for our show, please email us at podcast@ballardspar.com. Stay tuned each Thursday for a new episode. And thank you all for listening, and have a great day.